Get ready for a courtroom moment that no one saw coming. A woman walks into court determined to challenge the system, confidently refusing to recognize the court's authority. Facing charges for driving with a suspended license, operating a trailer without a plate, and having no insurance, she immediately begins pushing back against the legal process. She repeatedly claims she does not consent to the proceedings, attempting to disrupt the hearing with arguments often seen in sovereign citizen cases. But instead of reacting emotionally, the judge remains calm, professional, and patient. Carefully explaining her legal rights, the judge warns her that refusing to participate could lead to serious consequences, including a possible arrest warrant. As tension builds in the courtroom, it seems like this case is heading toward another dramatic standoff between the defendant and the legal system. Then something unexpected happens. An attorney steps in and advises her to be cautious about what she says, explaining that her statements could be used against her in court. Despite initially refusing to enter a plea, the judge schedules the case for a jury trial. Just when it looks like she is fully committed to fighting the system alone, she suddenly makes a surprising request that changes everything. In a follow-up court appearance, now standing beside her attorney, the situation takes an even more shocking turn. The case is dismissed after the officer involved fails to appear, bringing the entire legal battle to an abrupt end. This case highlights how quickly courtroom situations can shift and shows why understanding legal rights and using proper legal representation can make a major difference, even in seemingly minor traffic cases.
1217275. Count 1, no plate on a trailer. Count 2, no insurance misdemeanor. Count 3, drive while license suspended. Appearance for the record, starting with, I don't think counsel is represented in this matter. So Ms. Woodford, state your name for the record, please.
I'm here by special appearance, by coactus.
And what's your name?
Cinnamon.
Last name too?
Woodford.
All right, ma'am. Now, you know you have the right to have an attorney in this particular matter. This is a misdemeanor matter, and by right under law, you have the right to have a representative in the form of an attorney for this particular matter. Would you like to have an attorney in this matter?
I do not consent to these proceedings. The offer is not accepted. I do not consent to being surety of this case and proceedings. I demand the bond be brought forth immediately so I can see who will indemnify me if I'm damaged.
Okay, so the question that I asked is that, did you want to have an attorney provided for you in this particular matter, Ms. Workford?
I do not consent to these proceedings. The offer is not accepted. I do not consent to being surety of this case and proceedings. I demand the bond be immediately brought forth so I can see who will indemnify me if I'm damaged.
Ms. Workford, you're quoting from civil, well, not even civil procedure. Right now, you're quoting from the UCC. This is a criminal/traffic matter. So those proceedings govern these type of cases and these type of matters.
What crime did I commit?
Ms. Workford, if you do not wish to participate, then what ends up happening is that this matter will go into a show cause. After the show cause, then it will enter into what's called a bench warrant for your arrest until you handle this matter, at least the misdemeanors. And these are all misdemeanor offenses. So that's how this is handled on this particular end and this particular point. The offenses that have been alleged at this point in time is that there were no plates on your trailer, that there was no insurance on a Chevy vehicle, that's a 2007 Chevy vehicle, and that the driver's license was suspended that you had. And so those are the offenses that have been alleged at this point in time. Right now, they are just allegations. So you have the right to have an attorney, which I don't know if you would like to have that right or not. You have the right to have a jury trial. You have the right to have a bench trial. A jury trial is a trial before 6 people of the community in the city of Detroit who come and they will hear the facts, and based on the evidence and based on the law will make a decision. A bench trial is the same thing, only a judge, being myself, would sit there and I would hear those same facts and evidence and apply the same law in the same way. You also have the right to plead to these matters. There can be an offer.
I'm not here
have to make. It's not going to go away. Okay. Just because you want it to go away, it's not going to go away. There is jurisdiction for it. So it's your decision on today. If you don't want to participate, then it's going to go into show cause because you can keep coming and it's just going to hang out there. But eventually we're going to have to adjudicate this matter at some point in time because it cannot remain on this docket indefinitely. So you have to make some decisions as to what you would like to do with these matters.
Well, I still do not consent to these proceedings.
Okay. So if you do not want to participate, I'm going to be forced to put it into what's called a warrant. You have to participate. So you have to come in and ready to go with something. I know you may not like it, but as a person who is a citizen of the United States of America, who is a person who lives in Michigan and is utilizing the services of our world and our community, these are the things that have been alleged. Now, if you're saying that the officer wasn't, correct in those or something, your license was valid or you had car insurance and you can present all of that, then we can try and figure out if we can get a new offer or something different. But other than that, you do have to stand for these particular allegations that have been made at this point in time.
Well, I never had a driver's license, so I still don't consent to any of these proceedings. So, I mean, I still don't consent to these proceedings. The offer is not accepted. So,
ma'am, you can stop reading that. I know they've given you a line cue that you are able to read off of, but this is as long as you utilize the services of everything in the city of Detroit and you fail to do those things, this is the ticket that proceeds. But I don't know that you failed. You said you don't have a license, but did you have car insurance at that time that you could present?
No.
Was it a trailer on the back of the vehicle?
Judge, I'm sorry. I know I'm not on this case, but if I could file an amicus brief of sort. Judge, I'm a little uneasy with, this is Matthew Dupree, PAID 0132. I'm a little uneasy with the questioning here just because technically if this matter were set for trial, what she says here could be used against her. And so I'm not sure she should necessarily be answering those questions.
You want your representation, Mr. Dupree?
She did not, Judge.
Did you ask her if she wanted your representation?
I did, Your Honor.
Did the court ask her if she wanted her representation?
You did, Your Honor.
You can continue to talk, Mr. Dupree. I appreciate you stepping in on her behalf.
I appreciate that, Judge. Your Honor, I'm just I just thought I would make that representation. I don't think the city attorney would actually pull the transcripts, but it is worth noting that anything she said here, could come back. So it might, I'm not sure that necessarily that questioning would be appropriate. Sorry, Judge. Thank you.
You're welcome. Thank you, Mr. Dupree. I appreciate you coming in to step to the rescue of Miss Woodard so that she understands.
It's Woodford.
Woodford. Sorry, ma'am. Miss Woodford. Miss Woodford?
Mm-hmm.
So how do you want to move forward with this?
For me, ma'am?
You have to have a bench or a jury trial. You told me you don't want to plead. That's fine. You probably should have a jury trial then. And I don't have any jury trials for this year.
Are you making that determination for me, ma'am?
If you don't make the determination, yes, the court is making the determination for you. Yes, because I have to move it. I have to move it. So it's either Attorney Dupree, can I have a bench trial now? I don't want to violate anything.
No, Judge, she has to explicitly waive her right to a jury trial, and strictly speaking, she has to do it in writing. So I would say if she's saying she will not plead, that would be standing mute, and I think the court would have to set it for a jury trial.
Okay.
Sorry about that. I had a very bad power surge.
I figured as much. So no, back on the record, I figured that it happened because you kind of froze up, and my clerk informed me that you froze completely. So
Okay, thank you.
You're welcome. Okay, so I'm setting this for a jury trial because the alternate is that I can put this in warrant status, and I don't want to do that unless I necessarily have to. So at that point in time, you can be able to have your day in court, to say whatever you want to say at that point in time.
Okay.
Okay? All right, so I'm going to, but I have to do a pretrial because I don't have any dates right now. But I have your name down, but that will give you the opportunity. You'll be able to talk to the jurors. You will have the opportunity to have testimony taken. I know you don't want counsel, but you can have the right to have counsel at that point in time. Would you like to have me assign counsel to you?
I need effective counsel at that.
In the matter of the people versus Cinnamon Cheyenne Warford, this is ticket number P1217275. Count 1, no plates or trailer. Count 2, no insurance misdemeanor. Count 3, drove while license suspended. Also calling ticket number SP110222272. This is no proof of insurance. Count 1 of that same ticket is no receipt of registration. This is the date and time set for a bench trial in this matter. Appearances for the record, starting with Attorney Baughman, please.
Good morning, Harry Baughman for the defendant. Your name, please, ma'am.
Senator Woodford.
Thank you, Ms. Woodford. These matters are set for trial. I do not believe there's been an officer who has checked in with the people being unprepared now at 11 a.m. approximately. At the case is set for 9. We'd ask you to consider a motion to dismiss here without prejudice. Okay.
No officer having checked in on any of these matters, the court is going to grant your request. I'm going to dismiss these matters without prejudice. You're all set, Ms. Woodford, okay?
Thank you.
You're welcome. Have a good rest of your day, okay?
You too.
What starts as a routine traffic case quickly turns into a tense courtroom battle over authority, rights, and the consequences of refusing to participate in the legal system. Cinnamon Woodford walks into court facing 3 straightforward charges: no plate on a trailer, no insurance, and driving with a suspended license. On paper, it seems simple. But from the very first exchange, it's clear this hearing is not going to follow the usual script. When her case is called, she doesn't respond the way most defendants do. Instead of entering a plea, instead of acknowledging the charges directly, she begins by stating that she does not consent to these proceedings. The words hang in the air. It's a phrase often heard in certain legal circles, where individuals attempt to challenge the court's authority by withholding consent. But the courtroom doesn't operate on consent alone. It operates on jurisdiction and law. The judge listens patiently. There is no raised voice, no frustration visible, just calm repetition of the process. The judge explains that the court has jurisdiction over the matter. Charges have been filed. A hearing has been scheduled. The legal process moves forward whether she personally agrees with it or not. Consent is not a requirement for the court to proceed. But Cinnamon continues. She asks to see a bond. She questions the legitimacy of the proceedings. She avoids giving direct answers. Each time the judge attempts to guide the hearing back on track, asking for a plea, explaining the charges, she redirects the conversation toward her refusal to participate under the court's authority. The atmosphere in the courtroom becomes tense, but controlled. The judge makes it clear that failing to enter a plea will not stop the case. If she refuses, the court can enter a plea on her behalf. If she refuses to participate entirely, the matter can escalate. A show cause hearing could be scheduled. Failure to comply could eventually lead to a warrant. These are not threats, they are procedural realities. Still, she holds her position. The judge then shifts focus to her rights. She is informed that she has the right to an attorney. If she cannot afford one, she may qualify for a public defender. She has the right to a jury trial. She also has the option of a bench trial, where the judge alone decides the case. These rights are carefully explained, point by point, ensuring there is no confusion. At one point, an attorney in the courtroom interjects, cautioning that anything she says could potentially be used against her at trial. It's a subtle but important reminder. Courtrooms are not debate stages. Every statement matters. Every refusal, every argument, every recorded word can become part of the record. Despite being given multiple opportunities to formally respond to the charges, she continues to resist entering a plea. The judge, maintaining composure, eventually moves the case forward by setting it for a jury trial. The process continues whether she actively participates or not. That's the reality of structured legal proceedings. And then something unexpected happens. After standing firm in her refusal, after repeatedly declaring non-consent, she suddenly makes a request. She asks for effective counsel. The shift is noticeable. For someone who began by challenging the court's authority entirely, requesting legal representation marks a turning point. It signals recognition, whether reluctant or strategic, that navigating the legal system alone may not be the best course of action. The hearing concludes with the case scheduled to move forward, now with the expectation that an attorney will be involved. When the follow-up appearance arrives, the tone feels different. Cinnamon stands beside her attorney. The courtroom dynamic shifts immediately. Instead of philosophical arguments about consent and authority, the discussion centers on procedural facts and case status. The attorney speaks on her behalf, ensuring her rights are protected while keeping the focus on the legal merits of the charges. Then another twist unfolds. The officer who issued the citations fails to check in for the hearing. In many traffic-related cases, the presence of the issuing officer is crucial. Without the officer's testimony or participation, the prosecution's case weakens significantly. As a result, the charges are dismissed without prejudice. Without prejudice means the case could technically be refiled, but for now, it's dismissed. Just like that, what began as a tense standoff ends quietly, not because of a courtroom argument about consent, not because the authority of the court was overturned, but because of a procedural absence. The entire situation becomes a powerful example of how courtroom strategy matters. Minor traffic violations can escalate quickly when defendants refuse to engage with the process. Challenging jurisdiction with scripted arguments often leads to additional complications, delays, and sometimes harsher outcomes. Yet in this instance, the eventual decision to seek legal counsel changes the direction of the case. Throughout the hearings, one thing stands out: the judge's composure. No matter how many times consent is questioned, the process remains steady. The law does not bend to frustration. It does not react emotionally. It proceeds step by step. For viewer, this case highlights the contrast between internet-driven legal theories and the structured reality of a courtroom. It shows how quickly things can intensify when a defendant refuses to follow procedure. It also demonstrates how dramatically outcomes can shift when proper legal representation enters the picture. What could have remained a prolonged legal battle over traffic violations instead becomes a lesson in courtroom dynamics. Words matter. Participation matters. Representation matters. In the end, the case doesn't conclude with a dramatic ruling or a heated exchange. It concludes with a procedural dismissal, quiet, almost anticlimactic compared to the tension that built at the start. But sometimes, that's how real courtrooms work. Not with fireworks, but with process. And in this hearing, the biggest turning point wasn't an argument. It was a decision.